The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Tuesday the 19th of January 2016 are currently trading with gold at $1,087.85 an ounce, silver $14.02 an ounce, Texas crude $29.42 a barrel, and Bitcoin is currently sitting at about 375 U.S. currency. Today in history, Wednesday, January 19th, 1977. West Palm Beach reported snow for the first time on record, with snow flurries reaching as far south as Homestead and even the Bahamas. In recent news, the UN is set to set up processing centers in countries near to Central America where people will be allowed to apply for refugee status without having to pay smugglers to take them to the U.S. border. People granted refugee status may be resettled in the United States or other countries. In a recent release, the UN said, quote, "The international community is currently experiencing a flood of migrants from countries in crisis, with the number of forcibly displaced persons in the world now higher than it has been at any time since World War II. Also, according to the United Nations, almost 60 million people worldwide have been forced from their homes by conflict, persecution, general violence, or human rights violations. The global population of displaced people is growing at a faster rate than the general population." Researchers from Durham University have discovered what appears to be a massive canyon system beneath Antarctica's ice. Using satellite data, geologists have mapped out a system of canyons over 1,000 kilometers long, which is over twice the length of the Grand Canyon, with pits that reach up to a kilometer deep. They were located in the Princess Elizabeth Land region on the eastern side of the continent. The Texas Department of Public Safety, or DPS, has confirmed that a highway patrol trooper, Terry Lockridge, 33 years old, was arrested last week on charges of aggravated sexual assault of an underage girl. Mr. Lockridge has been with the DPS since September of 2009. Officials say that the case is still under investigation. The Lone Star Lowdown is currently looking for sponsors, so if your product or service you'd like to advertise with us, feel free to give us a call at 210-363-2257. This has been your Lowdown for January 19th, 2016.
Okay, howdy. This is Randy Kelton, Deborah Stevens, Rule of Law Radio on this Thursday, the 21st day of January 2016. And I'm going to start out tonight talking about grand juries. I had someone that was working on a criminal complaint. I probably should address that first. He wrote up a criminal complaint a couple weeks ago and sent it to me and had me go over it. And I was real diplomatic when I called him back and told him it was really a piece of crap, that it was absolutely atrocious. It was horrible. He did everything wrong. So I gave him some instruction, and he went to work on it and sent me another piece of garbage. And I tore that one to pieces, and I sent it back to him and gave him some other documents to read. And unlike a lot of people that we give suggestions to, he actually followed them. And he just sent me back this criminal accusations against a traffic court judge. And I'm going to read it to you. Now, he starts out, right off the bat, he makes one little error, or two errors. He starts out by quoting some code and case law. Now, I have a little bit of objection to that because you're writing this for a grand jury to read. And before you tell the grand juror anything about what's going on, you start throwing law at him, and his eyes are going to go glassed over. I'll read this anyway. Under our system of government, upon the individuality and intelligence of the citizen, the state does not claim to control him or her except as his or her conduct to others, leaving him or her the sole judge as to all that affects himself. Mugler v. Kansas, 123 U.S. 623. All laws and practices which are repugnant to the Constitution are null and void. Marbury v. Madison. Everybody should know that one. Okay, now he goes to, on the 5th day of May 2015, 7:03 a.m., defendant was brought before Judge Dwight to be arraigned for an alleged traffic offense. He goes through the facts of the hearing. He calls it an arraignment, but it actually couldn't be an arraignment. We may talk to that later. And then he goes to some more code. Article 1.03, Texas Code of Criminal Procedure, object of this code. This code is intended to embrace rules applicable to the prevention and prosecution of offenses against laws of this state and to make rules of procedure in respect to the prevention and punishment of offenses intelligible to the officers who are to act upon them and to all persons whose right are to be affected by them. It seeks to adopt measures for preventing the commission of crime, to exclude the offender from all hope of escape, to ensure a trial with as little delay as is consistent with the ends of justice, to bring to the investigation of each offense on the trial all the evidence tending to produce conviction or acquittal. And this one's highlighted, to ensure a fair and impartial trial, and the certain execution of the sentence of law when declared. Next one, Article 104. Now, this is right at the front of the Texas Code of Criminal Procedure. Article 1.04, due course of law. No citizen of this state shall be deprived of life, liberty, property, privilege, or immunities, or in any manner disenfranchised except by the due course of the laws of the land. Now, I've stated before, and we've had people come on the show and complain that a judge chastised them for bringing the Constitution into the court. And while it sounds horrible, it's not exactly incorrect. I wouldn't bring the Constitution into the court because I don't need to. The Constitution doesn't grant you any rights. It merely directs public officials not to infringe on certain specific rights that you already have. And this particular statute is a reflection of a constitutional provision. So you don't need the Constitution. You go into the Criminal Procedure Code, and just about everything that's prohibited in the Constitution has been codified in the statute. Okay, then he goes on to the 29th day of May. Defendant appeared at the town of Addison Court for initial hearing. I won't go through all of it. Defendant submitted some motions. On the 18th day of June, defendant hand-delivered 4 defense motions. On the 25th day of July, in response to a letter from Judge Dwight, defendant submitted 988 pages of case law. He filed Eddie's pleadings, or motions and pleadings, and the judge demanded case law for all of them. This guy gave him 988 pages of case law from 19 different Supreme Court cases. And then he quotes here, U.S. Constitution, Article 4, Clause 2, the Constitution and laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, and in any constitution, and in the Constitution or laws of any state to the contrary notwithstanding. I'm sorry, anything in the Constitution or laws of any state to the contrary notwithstanding. Okay, on September the 1st, 2015, Judge Larry Dwight held motions hearing. Defendant submitted the following motions. These are Eddie's motions. Judge Dwight opened the motions hearing, calling defendant and the city attorney, Larry McCollum, to the bench. Judge Dwight asked if there were any statements to be made. Prosecution stated he had no evidence to present to the court and was done. Judge Dwight attempted to gavel the hearing closed. Defendant interrupted. Defendant prepared and started reading a short one-page opening statement. Defendant was stopped in the opening line and never allowed to continue. Judge Dwight immediately interjected loudly, stating he was not going to hear this. Defendant stated Judge Dwight was prosecuting the case. Defendant stated it was the duty of the prosecutor to prove the case. Judge Dwight raised his voice loudly, yelling at defendant. He stated, "You don't know the law and you can't speak the law." Judge Dwight told defendant to shut up in no uncertain terms. Defendant held up Texas Criminal and Motor Vehicle Code stating this is the law. Judge Dwight replied, motion denied, gavel the case closed. Okay. That's what this complaint is about. The judge wouldn't let him present his case. Where rights are secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda v. Arizona. Okay, Article 1.05. We read 103, 104. Now we go to 105. Rights of the accused. And this is right out of the Constitution. In Texas Constitution. In all criminal prosecutions, the accused shall have a right to a speedy public trial by an impartial jury. He shall have the right to demand the nature and cause of that accusation against him, and to have a copy thereof. He shall not be compelled to give evidence against himself. He shall have the right of being heard by himself, or counsel, or both, shall be confronted with the obtaining witness against him, shall have compulsory process for obtaining witnesses in his favor. No person shall be held to answer for felony unless on indictment of a grand jury. Officers of the court have no immunity when violating a constitutional right from liability, for they are deemed to know the law. Murdoch v. Pennsylvania, 319 U.S. 105. And I charge, therefore, that on or before the making file of this complaint, on or before the blank day of blank, whatever that was up there, in the county of Dallas, state of Texas, Judge Larry Dwight did then and there unlawfully and willfully violate Section 36.05 Texas Penal Code titled Witness Tampering Against Peace, Dignity, State of Texas. Now, that is well done. This is what I'm talking about. This is how you prepare a criminal complaint. This gives the grand jury everything it needs. And here it doesn't really matter if the grand jury likes the judge or approves of the judge. It gives him facts and law. If you write a complaint, this is how you want it to come out. So, Scott, nice work. Scott sent it to me earlier today and wanted me to read it. And compared to his previous work, I was very pleasantly surprised. This was a nice piece of work. Well, I owed it to Scott to read that. And I hope you get something from it. When you write a legal document, first thing you want to do is present the facts. You always keep in mind what a judge must do. The judge has a duty to determine the facts in accordance with the rules of evidence. And in order to get facts in the case, you need the facts presented. The best way is by verified affidavit, but that's not enough. You have to establish foundation for the facts. So you start out at the beginning and you pretty well tell everything. You want to give facts that may not exactly go to the adjudication of the case, but they set up foundation for the facts that do go to the adjudication of the case. You can't just throw a fact out there without context, and foundation is effectively context. And when you write a statement of facts, I generally put each fact on a separate sentence. I may combine them later, but generally not. I want each fact separate, period at the end. They stop at the end and go to the next line. And let me see how much time I got. Okay. And when you write a fact, at the end of it, put comma, in my opinion. If you read the sentence and it makes sense, it's not a fact, it's an opinion. Take it out or rewrite it as a fact. Hang on, Randy Kelton, Deborah Stevens, Wheel of Law Radio. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Deborah Stevens, Wheel of Our Radio, and I'm going to turn the phones on. We'll keep the phones on all night. If you have a question or comment, give me a call. But in the meantime, I'm preparing a set of documents for our Texas Rangers. The Texas Rangers have been empowered to take over the investigative function of the prosecutors' public integrity units. We had a few of those around, and if you listen to the show a lot, you know that I've argued that a public integrity unit for attached to a prosecuting attorney's office is criminal, because a prosecuting attorney has no power to investigate a complaint against a public official. That's strictly left to a grand jury. And so when a prosecuting attorney is made known that a public official has violated a law relating to his office, he's required to reduce complaint to information submitted to the grand jury. He used to say forthwith. They took that out. And he's also to submit a complaint to some magistrate. So he can't investigate it. The legislature said, hands off. But Ron Earl put this unit together so he could use the investigative unit as a political tool to beat up public officials that didn't do what he liked. Case in point, Tom DeLay. Ron Earl, local Travis County District Attorney, down here in Podunk, Texas, took out the second highest political official in the country. And what he did was horribly illegal. Nobody ever accused Tom DeLay of a crime. I was going to read over a presentation I sent to the lawyers for Governor Perry. Governor Perry, same way. Nobody ever accused Governor Perry of a crime. And we do have a caller, Jeff from Mississippi, and I've been wanting to get him back up. If I get time, I'll go through this. It's effectively written as a habeas, but I sent it to his lawyers rather than filing it as a habeas. Don't know if they ever read it, but they sure didn't get the case thrown out. Okay, we'll go back to this if we have time. We got Jeff in Mississippi. Hello, Jeff. What has been going on with you?
Thanks for having me. Well, thanks for having me on. I've got a couple of questions, and we can just go through them and answer them pretty quick so we can get back to your topic. The first question that I've got is I'm writing my complaint, and something that really, really confuses me is when you hear someone say, do not use conclusory adjectives in your facts, such as he stole my lollipop, he did it recklessly, wantonly, and intentionally. I've been warned to leave those out, but yet I'll read complaints where they're put in and they say them. So that confuses me. Do you want to use intentionally, wantonly, and recklessly in your causes of action?
No. Here's how you do that. You give a statement of facts, and whoever's saying that with a complaint is not correct. If you're filing a civil action, then a civil action you want to give a statement of facts because you want to get those facts into the record. But when you're filing a criminal complaint, you're not writing that for the court. You're writing that for a grand jury. And there is no technical prescription for how a citizen must write a criminal complaint. And that's because complaints are intended to be written by non-professionals. So there is a lot of leeway granted in the writing of a complaint. So in that regard, I take some liberties. Not so much for the purpose of taking a liberty, but from keeping the complaint from being too long and too hard for an ordinary person to understand. Mm-hmm. When you're doing a civil case, you're writing this for the judge. So the judge is going to read down your statement of facts, and if you have constructed your facts carefully, then he will, like any human being, when they're reading, when they're putting together bits and pieces of information, they try to establish referential index, a way to connect logically one piece to the next, to the next, to the next. So you write out all your facts first, and then you determine where you want to take your reader. What conclusion do you want your reader to come to? And then all of the facts that are essentially irrelevant. Now, some facts don't exactly make a claim, but they establish foundation for a claim. Where a question would come into the mind of the reader, you need to answer that question. When you start stating the facts, if you jump over something and the reader's going to say, wait a minute, there's something missing here. You've lost a reader. You've lost flow. So you want to anticipate the question that's going to come to his mind. And if you need a fact in there to answer that question, you put that back in. But otherwise, you take all the facts out that don't lead your reader to connect your facts together in a way that will lead him to the conclusion that you want him to come to. Writing an effective statement of facts is an art form. Okay, once you have the facts done, you set that into a statement of facts, you convert it into an affidavit, have it verified, and file it as an attachment to your suit. That's how you get the facts before the court. The only way these facts won't be accepted by the court is if the other side objects to one of them and then the judge makes a ruling on one. Otherwise, you have your facts in the court that way. When you're writing a criminal complaint, it's a different deal. You're writing to a grand jury of your peers who don't necessarily know anything about how to stitch these facts together. So I generally write a statement of factual accusation. My term, made it up, but it's similar to points and authorities or a brief. I call it factual accusation because I write the facts first, save that as a statement of facts, and then I take my statement of facts and I start going down through the facts, and when they reach a point to where a reasonable conclusion should be made, I put in that conclusion, and I put in the law that supports the conclusion. And that's exactly what Scott did in his complaint. He told the jury, this is what the judge did, and here's the law that relates to what the judge did, and this shows why what the judge did was improper. So he just walked down on the salient pieces, and he did a good job of taking out all of those facts, all of those things that really PO'd him, that really annoyed him and got to him and frustrated him, that he really wanted to rub in their faces. But it didn't lead to his outcome, so he took them out. And that takes a discipline to only put in what you need. You start putting in stuff you don't need, you start sounding like somebody who's angry and just trying to get somebody in trouble because you don't like what he did. If you keep it clean, keep your facts going specifically to the law that you state, it makes for a nice read. This one makes for a nice read. I read through it, and I didn't trip over any major questions. I never lost flow. Now, I could have asked a whole bunch of questions, but in reading through it, I didn't need to. I mean, if I didn't know anything about it, I would have just flowed right through it and never hit a bump. Hang on, Randy Kelton, Rule of Law Radio, we'll be right.
Is your home as neat as a pin, or is it jam-packed with stuff? I'm Dr. Catherine Albrecht, and if you're tripping over things you'll never use but just can't throw away, I've got some advice that can help you streamline your life.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Clutter. It messes up your space and clouds your thinking. If you're drowning in a sea of your own possessions, you may need to change the way you think about things. Simplicity expert Leo Babauta says clutter may mean you're holding on to the past, especially if you're keeping things to help you remember people or events. My husband and I struggled with a ton of sentimental baggage ourselves till we finally hit on a workable solution. Rather than hang on to that 8th grade chess trophy or that old guitar you played in college, take a photo of it, then get rid of the original. The clutter leaves your home, but the precious memory remains. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Mr. Officer, you're taking the law in your hand. Won't you follow the law of the land? I don't understand. Your job is to protect and to serve. not beat and abuse. Officer, when you gonna stop abuse your power? 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 So please, Mr. Michael, and teach officers not to abuse their power. Send a request to the leader, the captain of all officers. Tell them to uphold the law. Please don't abuse their power. The beat and the beat and the cheat and the cheat and the like every hour. So Mr. Officer, please stop abusing your power. You pull me over and tell me be silent.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Jeff in Mississippi. Hold on, Jeff. Let me unmute you. Okay. Where were we?
I just wanted to recap real quick then. In my statement of facts, if I'm using conclusory adjectives like he meant to hit me or intentionally or wantonly, I just need to take those out?
No, you can actually leave those in if the wanton is implied from the facts.
Okay.
Now, if he tripped over a banana peel and threw his arm back and bloodied your nose, then you can't say wantonly. Yep. But if he walked up to you, raised his arm, swung his arm around and connected with your nose, that's wantonly as the element of the crime intends. Keep in mind, all crimes are thought crimes. Mm-hmm. Now, we have a lot of people complaining about that, but all crimes are crimes of intent, not of action. I once punched a woman up beside her head with every intention of knocking her smooth out. So, did I commit a crime? The facts were, we were in Lake Michigan. She got caught in a riptide. I swam out to get her, and I'm having to struggle because the riptide's pulling us to the bottom, and I'm having to shove my feet against the bottom and shove her up and then jump up myself to get up out of the riptide. And I shoved her up and came up, and she latched on to me, squeezed me so hard I couldn't breathe, and nearly drowned us both. I got loose from her, got a breath of air. She grabbed me again, and I did everything I could to knock her smooth out. Well, I didn't knock her out, but she quit grabbing hold of me and let me drag her in. All crimes are thought crimes. It's not what you did, it's why you did it. So, in that regard, you state your facts. State your facts as facts. He did this, he did that, he did this. Therefore, he wantonly, you state your conclusion in the verbiage of the element of the crime as closely as you can.
All right.
Does that make sense?
Yeah. Now, my second question is kind of a strange question. I've been listening to seminars, and I've heard people say that it is impossible, if you're going for a civil suit, Title 42, it's impossible to sue a judge or a clerk unless you've actually got proof that they're committing fraud. And I mean, like, if they're really stepped up to the microphone and basically admitted it. Now, in my case, I really do. I've got the clerk of the court testifying in court that I'm supposed to be arrested. However, she has no record as to why. She just claims under oath that she just felt comfortable, that she knew I'm supposed to be there. And then I have on record me asking the judge, why am I arrested? And he's not giving an answer. He's refusing to give an answer. So can I go ahead and sue these people? And if it's not, if I'm supposed to...
TWEAL, VUS. A lot of people misuse TWEAL. They ask somebody a question, and if the person don't answer the question, they call it fraud. Well, it's only fraud if you have a duty to answer. And in this case, you ask the judge for nature and cause.
Yes.
Why am I being arrested? He failed to provide nature and cause. He had a duty to provide nature and cause. And according to TWEAL, that's fraud.
Okay. What about the clerk?
Hold on. Another one. There's one place where the states, municipalities, counties all waive their sovereign immunity. False imprisonment.
Okay.
That's precisely what this goes to. But That's what you were saying about it's almost impossible to sue a judge. That's the reality. That's not the law. The law says the only time you can sue a judge is when he acts outside his subject matter jurisdiction. And another way of saying that is when he performs an act that's outside the scope of his authority. Committing crimes against you is not within scope. We have a case in Texas where a jailer picked up a woman at one facility, 19-year-old girl, driving her to another facility, stopped halfway there and raped her, and then took her to the second facility. Well, she sued. And he claimed immunity. And the court said, rape is not within scope. Since the act was not within scope, there is no immunity. Committing crimes against you are not within the scope of the judge's authority. False imprisonment may or may not be a crime in Arkansas. The false imprisonment is not a crime in Texas. False imprisonment is a cause of action in Texas. The crime is kidnapping. We could claim false imprisonment if they had a statute for it, but we don't. So the crime is kidnapping, and the tort is false imprisonment. You might want to check that in Arkansas to make sure that if you charge him with false imprisonment as a crime, that it actually is a statute. Did I get off topic?
No, you're good. Just with the clerk, what my only concern would be is if I listed the clerk and the judge as defendants, and then the court came back.
Okay, hold on. Clerk. What part of a clerk's duty involves instructing the judge to arrest you?
She didn't. The state filed for a motion to have me arrested for failure to appear, so they called the clerk on the stand to see if she was comfortable if I knew that I was supposed to show up for the date. And she said she thought she was comfortable.
Oh, that's different. So the clerk is a witness answering questions.
Yes, against me.
Can't be sued. Absolutely cannot be sued, period.
Okay, good.
Even if she lied like a dog, she can't be sued.
Really? Why?
Well, they want people to be able to comfortably testify and not have to worry about getting sued about every word they say.
Okay.
When you're called on the stand, you never have to worry about being sued over your testimony. Now, you can be prosecuted for perjury, but you can't be sued. You can't slander someone from the bench, from the witness stand.
All right.
You cannot be sued for it. So I would not go after the clerk if that's what she did. Now, if she committed aggravated perjury, but then again, if she testified to what she thought or felt, you're not going to have a shot at her.
Got it. Okay, I'll just take her off.
I would do that. Unless you have something really compelling.
Well, that leads me to my last question. That is, let's say I left her on the complaint, and then what happened is exactly what you said, is that I can't sue her. Would that destroy my entire complaint, or could I just...
won't hurt it at all.
Okay. I'm done. Thank you. I will call next week.
It just costs them a little. It'll cost them a little more to get it thrown off. That's all.
Okay. Thank you.
Okay. You got any more for us? I guess not. Randy Kelton, Rule of Law Radio. Our call-in number 512-646.
Easy.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're going to Tim in California. Hello, Tim.
Hello.
Okay, what do you have for us today?
I was the person that had actually written you an email regarding the fraud that was perpetrated against myself and my wife regarding our homes. with all the illegal activities that were associated with the securitized trust in the 2007-2008 timeframe. And we
okay, can you give me a brief synopsis?
Yeah, brief synopsis is we actually owned some high-end homes in an exclusive area in California, Southern California, Orange County. And one of the homes we were selling, a person came to our door and was involved in the mortgage industry and educated me as to all the fraudulent things that were going on. I, at the time, was starting up a technology company, and I had to make a business decision on what I was going to do. And when I researched what this person had told me, I found it to be true. So I became a conscientious objector to the fraud that was perpetrated against homeowners after these securitized trusts had been used to rip off money from the institutional investors. So at the same time that was happening, I ran across Lynn Sismoniak in Florida, where she had actually blown open wide the robo-signing issue, where people were paid $10 an hour to act as trustee secretaries or secretaries of the bank, when they were just people right off the street getting paid $10 an hour to forge signatures so that the bank could initiate an unlawful detainer action for no more damage than $15,000, and that was used to illegally evict people like myself out of our homes. Even when we were fighting in the court to have the opposition prove that they had legal standing. So it uncovered a RICO scenario. I've been in a situation where I've had to recuse federal judges. The best case is our own property. My wife, we entered into a Chapter 13 to protect our interests. The argument being we have to have our properties to properly reorganize because effectively they stole the properties, all of our down payments, and so halfway through that case, the judge was replaced by another judge that effectively research provided me the reality that judge had actually been an employee of the successor in interest of Countrywide, which is Bank of America, for 15 years prior to becoming an attorney general for 2 years before being placed on the bench. That judge was asked under oath by my wife if she had any 14th Amendment right conflicts, and that we have under the Constitution and the federal court jurisdiction the right to a fair and impartial tribunal. The answer was, this is not the proper venue for that question. After that particular hearing, she accused me, even though it wasn't my case, she accused me as a threat because I had requested her financial information from the Fair Practices Judicial Committee in Washington, D.C., so she could redact her financial information. Fortunately for us, she had been divorced, and we were able to find out all the proof of the fact that she is a stock owner in Bank of America, had been an employee, had a 401k, had a pension with Bank of America, and was sitting on a case where Bank of America was involved as the successor in interest of our property, allegedly. So if you're not familiar, Countrywide was one of the big front operations to the whole crash with Lehman Brothers and all the toxic assets. Effectively, when there was a case, Kemp versus Countrywide, where Lindy DiMartini, under oath in federal court, stated that she's an officer of Countrywide, that they never transferred the promissory notes to the securitized trust. And the reason they didn't do that is because they had sold those promissory notes to multiple institutional investors. So which one do you send it to? So effectively, they destroyed that evidence. And that's what caused the whole purpose of the robo-signing, is they needed to have some kind of legal way to evict people from properties that they had no longer, for their own greed purposes, had a legal chain of title. So where I'm at this point is final move before I believe a fair judge in my own case. And I just want to make sure that I'm prepared to the best of my ability.
Okay, hold on. Are you still in bankruptcy?
So I'm not in bankruptcy exactly right now, but the last time what happened was there was a docket that I wasn't familiar with, which was, I think, the damages docket. And they had put in one of these other illegal loans where it was actually it was a HELOC personal loan, but then they tied to the property, and I didn't see that, so I didn't argue that, and I had to dismiss. So I filed.
Okay, wait, hold on. You had the bankruptcy was dismissed?
Without prejudice. Yeah.
Okay.
I asked for a dismissal without prejudice.
Hold on.
With prejudice. And the judge cited for me.
When you filed for bankruptcy, did you claim the property as unsecured?
Correct.
No, that was correct. So you did claim it as unsecured.
Right. Exactly. I was a fee simple owner of the property as I filed on my form.
Did you get a ruling on? Did you have a evidentiary hearing on standing of the claimant?
No, because we've never been able to get to that point because they keep doing all types of different procedural tactics to get away from even arguing the law. So that's what I'm looking to do. I'm going to refile, and I'm going to move straight to quiet the title, and I'm going to put in a...
Okay, hold on. Have you filed a qualified written request?
Yes.
What did you claim as an accounting error?
I can't remember. I have to go back and look at that. I'd have to go back and look at that.
Okay. That is really, really important.
A little bit.
Okay. If you've filed what you called a qualified written request and you did not claim an accounting error and demand that the lender correct the error, then it wasn't a qualified written request. Now, I have a qualified written request. It's also a debt validation letter. It's also a demand under UCC 3-501. And most important, it's a notice of rescission. I'm going to suggest that you file this. And the reason I asked about the accounting error is we have a real humdinger that we can use. You got your HUD-1 settlement statement.
I do, but the problem with that is the legal situation is the bank that I did transaction with no longer exists. And
wonderful.
So my legal position is, unless, under a Supreme Court ruling, right, they have to bring an unaltered wet signature note in order to prove legal standing. They can't just bring, a deed upon trust because...
Okay, hold on. You're in California?
Correct.
Right now in California, that's all they need. However, we are waiting for a decision from the Supreme in California on the Yovanov case. And we also have a case with someone that I'm working with in San Diego. In that case, we're asking the court to distinguish Jenkins. This all goes to your right to challenge an assignment or an appointment. In California, the courts have mostly held that since you're not a party to that transaction, you have no standing to challenge it. But I seriously suspect that the Supreme picked this case up because they intend to either overrule Jenkins or distinguish Jenkins. Jenkins is the one they use to say you can't challenge these documents. And they present Jenkins as if it says you don't have standing to challenge these documents, but that is not what Jenkins says. What Jenkins says is you can't just willy-nilly say, I don't believe that's a proper document, and then take an action and demand discovery. They're calling it a fishing expedition. They're saying, Jenkins said, unless you have actual evidence that the document is fraudulent or improperly filed, then you don't have standing. But if you have evidence, you do. So we're asking, in the case in San Diego, we're asking the court to distinguish Jenkins and say, that Jenkins didn't say you don't have standing. It says you don't have standing unless you have some reason to believe. But we have the Yovanov case, which may well handle this issue. We really believe that the Supreme picked up Yovanov in order to validate Glaske. And Glaske's the one that said you do have standing. Until that time, what you're talking about is not really something you can adjudicate in California, because the court's going to blow you right off. So that's why I was going for this, the bankruptcy side, in claiming the property is unsecured, because what you do there is you change things around. The trustee of the bankruptcy court has a duty to protect the assets for the proper debtors. So when somebody makes a claim, they have to prove it to the trustee, not just to you. Hang on, go into break. Randy Kelton, Wheel of Law Radio. Our call-in number, 512-646-1984. We'll be right back.
They want to chant down Babylon and burn down the whole nation. But of them operate the land wrong. I'm going to say Republican and them a scratch, man. Tell them I'm a libertarian. Them say we back to
Okay, we are back. Randy Kelton, Deborah Stevens, Rule of Law Radio. And before we get back into our subject, I would like to remind everyone that we have our annual fundraiser going. And we have another gun giveaway. Go to logosradionetwork.com. And we have a Spike Skull Lower Receiver as the first prize and a Taurus Curve automatic pistol for the second prize. Every $25 you donate will get your name in the drawing for one of these prizes. And we certainly can use the help. It's sometimes really a struggle to keep this network going. I know Deborah and I and the other hosts, we not only contribute our time, we also contribute money to keep this thing going. We need all the help we can get. So if the information you receive here is of value, please help us keep this on the air by returning some of that value so we can keep the doors open and keep the information coming. Okay, we're going back to Tim in California. Tim, been having a little difficulty with your sound. Can you move your mic a little away from your mouth, just maybe down under your chin or something? Your mic is kind of booming at me.
Sure, is that better?
That's better.
I can prove fraud back to the robo-signing. Because we own multiple properties, I actually have a forensic document examiner evidence on docket of my wife's bankruptcy of the fraudulent activity regarding the...
Wait a minute, hold on. You said a forensic document examiner. What documents did he examine?
He examined the trustee's deed upon sale or alleged trustee's deed upon sale, which is what they need to claim that there was a transaction from the original loan holder. And all those documents have been proven fraudulent. And in addition, I was able to get the pooling and service agreement of the alleged new holder of securitized trusts for each property, and the cutoff dates don't match the filing.
Okay, wait a minute. As to, there's a lot of stuff around the internet about going after the securitization of the note. And I'm very familiar with that side of this issue, but I am perplexed. That is the hardest route to go. Have you read the deed of trust carefully?
Yes. All that was stating was that their own filings contradict each other. That's really the argument that I'm making is we've proven fraud with respect to what was filed to initiate the unlawful detainer, and in addition, it violates the alleged legal position of the securitized trust, which is claiming...
Okay, hold on. Okay, I have a concern here. You're talking to me about issues that I go to every once in a great while. I have one right now that I'm going to that issue. The only reason I'm going to that issue is because I don't have anything else. I almost never have to go to that issue because I got so much stuff. In this particular note, I have a note by Bank of America N.A. in 2004. I have a assignment of the security instrument from Bank of America to Christina Trust in 2014. I have a deed of trust, but Christina Trust. Man, I don't have much of that to work with. And then we did a check on Bank of America, and if they sold this thing, they didn't file on it anywhere because there's no records on it. Extremely rare that I come up with something like this. What I always come up with, and in looking at these documents, it took a close look, but I found something. Bank of America N.A. was the lender. The assignment of the security instrument from Bank of America to Christina Trust was done by Bank of America Home Mortgage. Muhaha. Bank of America Home Mortgage is not Bank of America N.A. So, without regard to the securities issue, Bank of America Home Mortgage, who the heck are you? And how did you get in this mix? Where did you get authority to assign the security instrument to Christina Trust? I'm not going to securitization. I'm going to chain of title and covenant 16 of the deed of trust. They're generally 15 or 16, depending on which document it is. The governing law and severability clause, you should have that memorized. Both parties to the transaction have agreed to abide by all standing law. I make claims under the consumer protection laws. I make claims of violations of the consumer protection laws, but I never, ever claim the remedy provided by the consumer protection laws. I claim a contractual breach. They violated a law. They breached the contract. Now, asking the judge to rule on securitization, that's a lot to wrap his head around. But breach of contract, that's not so difficult. And if he gives you a ruling on breach of contract, he doesn't change the legal landscape as he knows it. This ruling goes specifically to the facts of this particular case and won't affect any other case. It's a lot easier to get the judge to give you a positive ruling when his ruling won't affect 10,000 other cases. Does that make sense, Tim?
Yeah, well, yes, and that's what I was hoping to hear. I'm looking for help.
Yeah. I'm not saying don't go to securitization, but go to securitization last. Go pull all those documents in the public record. The court, the lenders over the last 15 years have made a horrible mess. And most of the time, I don't have to go anywhere but the public record and the documents that the lender tends to hold. I look in there and I found incredible messes. I've got one right now where those morons filed in the record a notice of loss of assignment. Oh, yeah, I'm down here in Louisiana. We have this big library down, this secure vault down here, and I looked all through it and I can't find an assignment to us. But then he immediately makes an assignment from them to somebody else. I looked at that and said, are you kidding me? Why on earth would you even file that? What were you thinking? There was a breach of title, and he waved it in our faces like a red flag. I'd have found it anyway, but he actually put a document in there stating that we don't have an assignment to us. I looked through all of our records, and I can't find one. Duh. I mean, this don't take a rocket scientist, and it doesn't affect any other case but this one. You go in with a quiet title and ask the court. And what I'd like to do is go in with declaratory judgment first. Don't go for the whole enchilada first. I want to go in with a quiet title action against a particular document and get them to throw in all their stuff, all of their arguments, all of their issues. Now I know everything they've got, even if they win this one, because now I'm going to go after the next document in line. If you look in the public record and examine it carefully, like today, I was looking through these, and it took me a while for this to come out at me that Bank of America N.A. was a lender, and Bank of America mortgage, residential mortgage, or whatever it was the one who did the transfer. You always find stuff like this. I find trustees selling the property, and they're never appointed a substitute trustee. They say you can't challenge this document. What I can do is say this trustee here is trying to sell my property, but there's nothing in the record that's valid that shows that this trustee has a right to sell my property. You might look at the code in California. We got some great code in Texas. We have one code in Texas that specifically goes to fraudulent filings in the public record. This was done because of the Republic of Texas, people who were filing liens against public officials. If someone files a document in the public record in Texas and it's fraudulent, and I send you notice that it's fraudulent, you have 21 days to remove it. If you don't, it's felony. Let's dance, Bubba. I file a felony charge against you, and then I file a quiet title against the document. If you lose the fight, then the felony charge becomes res judicata.
Wow.
Raise the stakes a little bit. In California, you're going to have a conversion statute. Conversion goes to theft of real property. Everywhere I look up, we have a 132, the Theft Liability Practices Act. Conversion in Texas is no longer a crime. it's been moved over to the Theft Liability Practices Act. And the crime is felony theft, 31.02 Penal Code. Everywhere I see that conversion lawsuit, I see 31.02 attached to it. There's ways of raising the bar, and if you've been in this fight for a while, I'm going to suggest to you, in the end, you'll never win the fight. Not completely, not directly, not through the courts. Just like this judge you had tossed, all of these judges, for the most part, are invested in the very securities that you're challenging.
Correct. Right.
Good luck on that one. So what we need is a way out for the judges. And when we come back, I want to talk about the pro se from hell. How many bar grievances have you filed?
None.
That took too long to answer. How many judicial conduct complaints have you filed?
None.
Oh, you don't understand what it means to be a pro se. Judges hate pro ses. But they don't hate pro ses because they file stupid pleadings. They file pro se. They hate pro ses because every once in a while they come across the pro se from hell. And we'll talk about the pro se from hell when we come back. You have powers and abilities lawyers do not have. Randy Kelton, Deborah Stevens, Rule of Law Radio, or call in number 512-646-1984. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me.
Okay, we are back. Randy Kelton, Deborah Stevens, Rule of Law Radio, and I'm talking to Tim in California. And Tim, where I'm going is a paradigm shift. Over the years, I've helped about somewhere between 600 and 700 people file federal lawsuits. And we can keep the lenders at bay for 4, 5, 7, 8 years. The guy we have in the Court of Appeals in California has held him off for 6 years on my first standing suit. That's just the first suit just to get their attention, and he's been 7 years on that one. So we can hold him off for a really long time. So it's a great remedy. Well, it appeared to be a great remedy. It turned out to be a horrible remedy because 95% of the people that we help file lawsuits just couldn't take the stress and they walked away. So it turned out to be a horrible remedy. So I had to back up from it. One thing is we never win at the end. The courts are corrupt. They're just absolutely corrupt. And I had to back up and look at how can we carve a remedy out of this mess? And it becomes clear that the only way to carve out a remedy is to make a deal. The problem I had for a long time is I tried to structure suits and claims in order to win the whole enchilada. And it took a long time for me to realize you're not going to win the whole enchilada. So let's back up and look at it different. Now I'm looking at it in terms of money. It's all about the money. It's never about the law. You'll never win your case simply because you have the law and the facts on your side. To think so is naive. You'll only win your case if you have the politics on your side, and all politics is local. So when we were going out, I spoke to the pro se from hell. That's about politics. And all politics is driven by money. In the end, it's all about the money. So how can we develop valid, viable claims that's going to give the other side a major headache trying to adjudicate? It's all about a money calculation. How can I bring something in front of the opposing party that's going to make it look like win, lose, or draw, this guy's going to cost me a fortune in adjudication costs and lawyer fees? And the courts almost never grant attorney fees in these cases. So they're not going to get their money back. We have people trying to do short sales. And they go to the bank, they go to the asset manager, and they say, hey, we want you to forego some of your profit. Now, the asset manager may want to do that because he wants his properties off his inventory, so we have to take care of them. So he's going to go to his boss and ask his boss to knock some of the profit off of this note so we can get this property moved. Well, the boss is going to say, hey, man, we got a right to that property. And I got the investors in the bank to consider. I can't just throw away money. I got to be able to justify it. So what are you bringing me as a calculation so I can justify cutting your deal? Well, the guy just sued the crapola out of us. And now it's going to cost us $13 billion in attorney fees to fight this no-good rascal. He just bar-grieved our attorneys, and they quit. Now the next one wants $100 an hour more because their insurance rates are going up. And he bar-grieved, and he judicial conduct complaint the judge is PO'd at us because we're dealing with this guy. We need to get rid of him. It's all about the politics. So, what are the claims that you can make that on the surface are the easiest to wrap your head around and sound good? Like I go to the court and say, Your Honor, I have this company, Bank of America Home Mortgage, and they did an assignment of this security instrument, but there's nothing in the record to show that Bank of America Home Mortgage is ever owned this note. And the other side's going to say, well, Bank of America Home Mortgage is a wholly owned subsidiary of Bank of America N.A. Well, that may be. But according to the case law, Bank of America Home Mortgage is not Bank of America N.A. And we have exactly that case on Chase and Chase Home Mortgage. It's exactly what the court said. Chase Home Mortgage is a wholly owned subsidiary of Chase Bank, but it is not Chase Bank. So, Judge, you need to strike this assignment of security instrument. And now we want to know how Bank of America Home Mortgage got this thing without it being reported the way Covenant 16 requires it to be. Now you have this bank here coming wanting to foreclose based on a covenant of the contract they're claiming we breached when they had already breached a covenant of the contract. We're not saying we don't owe them money. We're saying that they can't use this vehicle to collect that money. They breached the contract and thereby repudiated it, so they could come into this court and claim the privileges granted in it. That's not a hard concept to wrap their head around. And they're going to look at it and they're going to say, well, they're going to file a suit. We're going to file a answer and opposition and motion to dismiss. And they're going to keep us in court for the next 5-6 years. And we'll tell them, we're going to lease the property out. We're going to make a lot of money on it. So take your time. But if you don't want to spend all these lawyer fees, let's make a deal. What will you sell me that property for? I have a lawyer that what we're doing here in the Dallas-Fort Worth area is people who are facing foreclosure, we get them to write us power of attorney. And the first thing I do is file my qualified written request. I asked you about one earlier. You want to file a qualified written request and claim all the amounts on the HUD-1 settlement statement as fraudulent. Because at closing, the lender didn't provide you with documentation to show that those fees that were charged on the HUD-1 were not otherwise forbidden to be charged by law, that they were for services actually rendered, that the amounts charged were reasonable, that the vendors were qualified vendors and not fiduciaries, not the front companies for your fiduciaries, and that the lender did not take an undisclosed markup on the amounts charged. This is all right out of the Truth in Lending Act. So they're all bogus. And we file a qualified written request claiming that all these fees are fraudulent and they're being improperly charged on the note and ask them to correct it. And then we demand that they produce the original security instrument for the original note for inspection. And we dispute all the debt. And then we put in about 25 pages of discovery. And they're going to read that discovery and say, this is garbage, I don't have to answer this crap, blah, 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 blah. The very last paragraph says, if you fail within the specified 30 days as allotted by law to properly validate this debt such that I can make a complete and proper calculation of the amount owed to the bank, consider this document as a notice of rescission. They never read it. They go through 25 pages of this trash discovery that they don't have to respond to. They never read that last one. You wait your 30 days. Now they got 20 days. They got 20 days under Jasanowski to either start the rescission process or file an opposition in the federal court. If they fail to do either, then the borrower may retain the property with no further obligation. We wait that 20 days, and then bang, we hit them with a quiet title action, claiming that under Jasanowski that on rescission, the note and the deed of trust is void, and ask the court to rule that the note and deed of trust is void. That's all we ask for in the quiet title. No damages. Damages will ruin everything. They'll screw you if you ask for damages. So you hit them with a quiet title, and then they're going to come to court. They're going to talk to you then. What we told the last lawyer is, look, don't even bother to answer this suit. Well, then why did you file it? Well, we just filed it so we find out who to talk to. Hang on, we'll pick this up on the other side. Randy Kelton, Blue Ball Radio. I call in number 512-646-1984. We'll be right.
A Virginia company has brainstormed a new idea to house aging relatives, a prefab cottage that fits in the backyard of a family's home. I'm Dr. Catherine Albrecht, back to tell you about a great idea called Granny Pods in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
For the elderly, moving into a nursing home can be devastating. But now a Virginia company is offering an alternative, compact, high-tech cottages that fit in relatives' backyards. The company, N2 Care, says its Granny Pods are selling like hotcakes. These 280-square-foot cottages have everything a hospital room does: safety rails, lighted flooring, a defibrillator machine, and electronics that monitor vital signs. The pods can cost up to $125,000, and you have to get local zoning approval. But for elderly folks who want to keep family in their lives and still maintain their personal dignity, these prefab homes seem pretty fab to me. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
We'll be kidding about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Yeah, who you want to chip? Who you take me for? Free Tolly? Who you want chip? Me no free Tolly. You can't chip me. What am I saying? Don't let them chip you in the morning, chip you in the evening, put a chip in your body. And anyway, you go computer ready. You can't hide me from nobody. When me say, chip in your mom, chip in your daddy, chip in your grandpa and the grandme, chip in me, chip in your baby, chip in your family, whole family, chip in your dog and the cat around we, chip in the beef and you still go eat me, chip in the fish, them all in the sea, chip in the shark and the whale around me. You know, see mankind, gone chip crazy. Them the kind of thing, man, they want to read me. Social security, them to tell.
Okay, we are back. Randy Kelton, Deborah Stevens, Rule of Law Radio, and I'm moving kind of quickly here, Tim, because there's a whole lot of information. It might be better if you call back tomorrow night where we've got 4 hours. But we're talking about a whole different paradigm. You as a pro se, you can do things that the lawyers can't. You can sting that lawyer every time he turns around. You file a bar grievance against that lawyer, and the state bar is going to get that grievance, they're going to throw it in the trash. They're going to send you this letter that says, we examined into your accusation, find it does not rise to the level of misconduct. And that's a good thing, because his insurance carrier knows they're going to do that. So how do they gauge their level of risk? By valid bar grievances? Heck, throw them all in the trash. By the numbers. 1 bar grievance first year in practice, they cancel immediately. 2 bar grievances any 1 year, they cancel. 3, they'll cancel your law firm's malpractice insurance. Makes lawyers absolutely crazy. And if they say one word to you about that bar grievance, you file a grievance against them for that. So you can kick them in their professional pants, and they can't do anything about it. Lawyers don't grieve one another. Pro se's can. Judicial conduct complaint against a judge makes them crazy. Raises their bond rating. If they're a federal judge, it's even worse, because when it comes time for a appeals court appointment, they look around and they got 40 judges here. And all of them essentially the same record. Oh, this guy's been filed judicial conduct complaints on him 4 or 5 times. He must not be able to control his litigants. They need a reason to toss him out. Doesn't matter if the complaint is valid or not. It stings them good. Now, the judge can't do anything to you about that. And get over this nonsense of thinking the judge has to like you. He's not going to like you. He's going to screw you. Even if he does like you. He's going to screw you no matter what. Because there's big money on the other side. So what you can do is get him so annoyed at you, but he can't get at you, that he goes to the lawyer on the other side and tells the lawyer, get this guy off my case or I'm going to kick your behind. It's all about politics. We can spend more time on it tomorrow, but if we're going to beat these guys, if we're going to win, well, I shouldn't say beat these guys. If we're going to win, if we're going to come away with remedy, and give them reason to do what they're doing right. We get in their pockets. And the way to do that is bring them to the table and make a deal. I know it sounds crappy and it sounds like we're giving up.
No, fine. I'm fine with that. I'm fine with that. I hear what you're saying. I agree. I've experienced enough to know that you're right.
And it's a lot easier this way. We have a lawyer that she does not adjudicate any of our cases. All she does is negotiate with the other lawyers. Lawyers don't want to talk to you. They definitely don't want to make a deal with you. So you go in and beat them up, kick them around a bit, and then you bring in your lawyer specifically for the purpose of negotiating a deal. And that way, like we have this lawyer, and I'm about to file an amended pleading on these lawyers, and they're going to have a fit. And my negotiating attorney is going to say, man, I can't do anything about it. This guy's a real jerk. So I'm afraid he's going to bar grieve me if I'm not careful. She gets plausible deniability. Come on, guys, do something so we can make this go away. We can all go home. It's all about making the deal. So I have one more caller. I need to get to him, but if you have time, call in tomorrow night, and we'll go into this into more detail. It's a lot more fun when you're going after them and making them dance.
I like that. That sounds good.
Okay, give me a call tomorrow night, and we'll go into this in a bit more detail. Okay, thank you, Tim. This is Randy Kelton, Rules Law Radio. We're going to David in Texas. Hello, David.
Hi, Randy.
Howdy.
Good. Thanks. Hey, I'm calling with the same thing about the last caller. My case is in here in Texas. It was a DWI. My lawyer was able to plead it down to obstruction of traffic. And the obstruction of traffic thing started 2 years ago. It's still going on. And I'm trying to see, right now they got me on one of those home breathalyzer things.
Okay, so you've already been through the case, and your lawyer's already thrown you under the bus.
Yes, and I got another date. He's trying to avoid jail time, and I'm trying to avoid I just want to get the judge to just drop this whole thing, and I wanted your advice.
Okay, in order to do that, have you read the specific statute that you're charged with?
Not yet.
You really need to read that statute and look at every one of the elements of the crime and make sure they have all of the elements of the crime, and then look at due process. Are you familiar with jurisimprudence.com?
No.
Okay, go to Juris Imprudence. That's JURIS Imprudence. IMPRUDENCE.com.
Okay.
That's one of my websites. And on there, I've got a bunch of frogs on there because I call this the Frog Farm Conspiracy. Top frog on the left goes to a writ of habeas corpus I wrote for a kid in Williamson County, in Conroe. I forget the county. Anyway, Montgomery County. But it tracks due process. In your case, they violated they committed at least 19 criminal acts against you. And I can say that with confidence because they do it every time they arrest somebody. The practices and the procedures that they use are illegal. So, if the case has already been adjudicated, so have you made a deal and are you still in the process of adjudicating the case?
Still in the process. Originally, they were going to give me 2 years probation.
Okay. Is this your first offense?
Yes.
Okay. Then look at due process. Okay, you understand that the prosecutor has got a whole stack of cases on his desk, and he needs to get rid of them. Mm-hmm. You have a lawyer. Is it a court-appointed counsel?
No.
Okay, good. You got a lawyer. You paid this lawyer. And very likely the lawyer's not doing his job.
Right.
Yeah, there's a good reason he's not doing his job. It's because he's a lawyer. And lawyers are terrified of judges. All these lawyers who defend DUIs, they do the same things. Primarily, it's the lawyer's job to ensure you don't have anything you can appeal with. And what he's going to do, he's going to take your money, and then he's going to do this little song and dance, seltzer down your pants. They got this set of motions that they file. And then the prosecutor comes in and argues against the motions. They argue back and forth, and it sounds like he's really working in your favor.
Mm-hmm.
What you don't know is that is a dance they're doing. He's probably filed this motion 500 times. He's probably had the same back and forth with the prosecutor 500 times. The prosecutor needs to allow the lawyer to look like he's doing something to earn what he's being paid. Once they do this little dance back and forth and the lawyer's used up all the money you gave him, he's going to toss you right under the bus. Unless you can give him plausible deniability. And we'll talk about plausible deniability when we come back on the other side. This is Randy Kelton, Deborah Stevens, Rule of Law Radio. Our call-in number, 512-646-1984. And during the break, go to logosradionetwork.com and have a look at our current fundraiser. We've got some drawings there for $25 to get your name in the drawing. We need all the help we can get. We'll be right back.
Easy.
Hello? Oh, man, in jail? Got busted up? Oh, man, I'm broke, dude. Some things in this world I'll never understand. Some things I really...
Okay, we are back. Randy Kelton, Deborah Stevens, Rule of Law Radio, and we're talking to David in Texas. Okay, the last case I had in Travis County, they dismissed the case to protect my lawyer from me. So I suggest you go to jurisprudence.com and read that habeas corpus. Read it twice. It walks right down all of the procedures they're supposed to take. Has nothing to do with DUI. Has to do with everything that happens after arrest. Then you can contact me. I have a bunch of motions associated with all of that. I can send them to you. And then you take them, give them to your lawyer, and insist that your lawyer file them in your behalf. And when he refuses to, then you file a bar grievance against him.
Mm-hmm.
And when you file a bar grievance against him, he's going to file with the court, asking the court to remove him from the case. And then you go in and file an objection to the court removing him from the case. And the court's almost certainly going to remove him from the case. Now you go back to the court and demand counsel of choice. This is something that's in law, and they all know about it, but they don't run into it often. You have a right to counsel of your choice, and you have counsel, and you paid counsel. And I suspect that counsel's at the point where he's about to ask you for a bunch more money. But even if you give him more money, he's going to throw you under the bus. So now's a good time to sting him. You bar grieve him. He's going to try to get removed, and you object to the removal. We just had one in the federal court in bankruptcy where they bar grieved the lawyer twice because he wouldn't file documents. They filed the documents themselves. The lawyer filed a motion to withdraw, and the client came in, and she took instruction well and objected to the withdrawal. And it got real interesting, and the judge finally told the lawyer, "Counselor, you're going to have to work this out with your client. She doesn't agree to your withdrawing, and I can't remove her." So about the only way the judge can allow the lawyer to withdraw is if you agree. So if he allows the lawyer to withdraw, now you have a right to counsel of choice. You go find the most expensive lawyer in town and demand that they appoint that lawyer.
Appoint the lawyer?
Pardon me?
They would appoint a lawyer?
Yeah, they may actually appoint them because they've done that before. They know the problem. And if you bar grieve the last one, whoever they appoint is going to know that you bar grieved the last one. And mostly what you get in these kind of cases in criminal is you get the lawyers who are kind of either new in business or aren't doing so well. You bar grieve them, their malpractice insurance starts between $25 and $40 a year. It's going to double immediately if they don't get it canceled. Bar grievance make them crazy. And then if they try to get removed and you fight removal and they can't get removed, now they're in a spot. This is how I got my last one thrown out. They appointed me counsel. I didn't ask for them. They called me in for a hearing, and I asked the judge, I told the judge I got this notice to be here, but didn't tell me why. So, well, we didn't see if you had a lawyer. I said, well, Your Honor, I got 28.01 Texas Code of Criminal Procedure, lists all those things you can order me to court for to see if I have a lawyer is not one of them. So we started out on a good note. But this was Ron Earl's daughter, so I figured she was good and political. I wouldn't get a more political judge, so I figured that was good. So I backed off from her. She said, well, Ms. Kelton, we need to know if you have counsel. Do you have an attorney? No, I don't. Are you going to hire one? Nope. Would you like me to appoint one? I don't care what you do. Well, Ms. Kelton, I'm going to appoint you counsel. Well, if you do, Judge, make sure you appoint one you really don't like. And she kind of laughed and said, well, we have an attorney wheel. You just get the next one. So you're off the hook. Yes, I am. They appoint me counsel. We go in this room. He starts telling me, oh, this is how things are going to go. And I let him rattle on a minute, and then I stopped him and I said, no, that's not how it's going to go. This is how it's going to go. You're going to go to the court and ask the court to remove you from this case. And I'm going to go to the court and tell them, don't you dare remove him from this case. He's my counsel of choice, and the judge is going to remove you from the case. And he said, yes, he would. Then I get to sue the judge for interfering with the private contract. He said, well, Mr. Kelton, I'm not under contract with you. I'm under contract with the state. I said, yes, you are, but I'm the intended third-party beneficiary, and I have standing under the contract. And he sat back with this look on his face. He's going to get me disbarred. We were in court. I'm back in the gallery, standing by the bar, and he's up at the bench with the judge and the prosecutor. He come over to me, and he said, prosecutor said he knows who you are, and if you start filing criminal charges, she's going to charge you with tampering the government document. And I look over at her, and I said, she said that, did she? She said, yes, she did. So when you get over here, I got about 30 of them. I pull a big stack out of my case. I need her to verify these in accordance with her duty under Article 2.06 Code of Criminal Procedure. And I pointed at her, you, get over here. And I turned to my lawyer, and I handed them to him, and he held up both hands with his palms out. I'm not going to touch him. I'm not going to touch him. Take him, you chicken. Well, the judge he recessed for lunch, and while we were out to lunch, they dismissed my case. He dismissed my case to protect my lawyer from me. I put on that show in front of the judge, and it told the judge I wasn't at least a bit worried about him. I certainly wasn't worried about the prosecutor, and I was fixing to crucify my lawyer. So now the lawyer has plausible deniability. Now he can do his job. If he tries to do his job without plausible deniability, he's not going to get appointed any more cases. He's going to get the judge's ruling against his next client. He's going to get screwed. Lawyers can't go in there and actively adjudicate your case. They're in business to make money. And if they actively adjudicate your case, the courts are going to beat him up big time. The only way he can actively adjudicate your case is if you give him plausible deniability. Or he can. And you would think, well, if they get mad at me, they'll gang up on me. No, they don't have time for that crapola.
Yeah.
They got too many cases to get through. They don't have time to gang up on somebody. It costs the state way too much money. So if you look like you're going to give them a good fight and you're going to cost them a lot, then we say, well, guys, let's make a deal here. First offense, reduce this thing to public intox. Give me a couple months probation. Let's go home.
Can I say something?
Yes.
Because the DWI case is gone. He already pleaded it down to obstruction of traffic. And now we're in the middle of now we're in the middle of an obstruction of traffic case.
Well, that's obstruction of traffic. What is that? Is that a misdemeanor? Or?
Yes. And I'm still messing with it 2 years later. They tried to give me 2 years probation, but my lawyer said, look, he told me, David, you don't want to do 2 years probation. And he advised me, don't go to probation. We'll get the warrant for your arrest. We'll come back and stand before the judge, and we'll ask if you could just pick up trash for a couple weeks. Are you following me?
Yeah. So they're going to give you, the lawyer's saying you should do community service instead of the probation.
Right, and I got the little, and then the judge just harassed me, the prosecutor just harassed me with this home breath test thing they got to do every 7 hours, and I got to pay for it. I got to do it for a month. I got and all that just to look good on paper so that he can come in front of the judge. Look, Judge, we've done everything you've asked. Can we just forget the 2 years probation? Can we forget jail time? The big one is, can we just forget jail time, and can we make a deal? Does that sound something that
sounds, in this case, I wouldn't bar grieve your attorney.
Right. And I was about to say, that's why I wanted to stop you. I really don't want to bother just, I don't want to bother the attorney.
It sounds like he's actually worked well in your case.
Right. And it's, in my case, it's the judge. The last time I went in front of him, the judge is all acting all wishy-washy. Like, you know how they act like, no, it depends on how I feel that day, what I'm going to give them.
Yeah.
So my question is, this has been going on, this obstruction of traffic case has been going on for 2 years. What can I do? What can I do? Is that too long? Is the judge taking his time?
I'm gonna suggest, with the seriousness of a DUI charge, be patient. I do a show on legal reform, and we talk about beating up the system and taking these guys to task, but only do that when your liberty's not at risk. I can go in there and I can fight them and I can have a great time with them because my liberty's not at risk. Well, it was that last time. I was looking at a year in jail, but they wouldn't have got a conviction on me. But if you can keep that DUI off your record.
And it's gone. The DWI is gone. Now it's just an obstruction of traffic charge.
Yeah, be patient.
I don't think I should do jail time for an obstruction of traffic charge.
Well, they don't want you in jail. It costs too much to put you in jail. If you've been out of jail this long and they've reduced it, be patient with your lawyer. Sounds like your lawyer's actually doing a good job.
Okay, that answers my question.
Yeah, I wouldn't complain about him. Send me his name. I'll send him an attaboy.
Okay, thanks.
I don't know many good lawyers. Okay, we are out of time. Thank you, David. This is Randy Kelton, Deborah Stevens, Rule of Law Radio. Make sure you go to logosradionetwork.com and check out our gun giveaway and help us out with our annual fundraiser. We need all we can get to keep this thing going. We'll be back tomorrow night on our 4-hour info marathon. So thank you all for listening, and good night.
Dangerous.